Started.
Okay.
Welcome, everybody. I'm Pat Whalen. I'm the director of the Niagara Global Institute, and Janine Brown-Miller and I host this every week. We're glad you're with us. I think you're going to enjoy the program today. Just to recap, we'll have 4 speakers today if Tom joins us. I'm not sure if Tom's on yet. Tom gives us an update on the...
He's on.
Okay, on the SBA stuff primarily. And then Janine is also going to talk after Chris and Chris. So at the top of the screen, note that this session is recorded. All of them have been. And there's a big long link there that tells you where you can access these. I know you can't see that or are not interested in copying it. So if you're interested in it and you can't get it, email me. I'll send it to you. We're planning on starting a YouTube channel, and we'll put all these on there so it'll be easier to access them. So with that, Tom Murdoch, please take it away.
Hi, everyone. Just had to unmute myself there. Hi again to everyone. I think I know most folks on the line, but for those of you who I don't, Tom Murdoch, I work on the economic development team at the University at Buffalo, helping companies find ways to partner, helping early stage companies find ways to partner with the university to ultimately create jobs in startup companies. And specifically, I look after a program called WIN, or the Western New York Incubator Network, which is a consortium of 11 incubators across Western New York, and Trek is one of those 11. And so it's a great pleasure to be here with everyone. And generally what I've been talking about on these calls are is the Paycheck Protection Program, and also the EIDL program, so Economic Injury Disaster Loan. And I think most of you folks have heard kind of an overview of this stuff at this point. What we're seeing now is EIDL is spent out and applications are closed, but Paycheck Protection Program got replenished about a week ago, and banks have started opening up their applications. The interesting thing about the way that this replenishment works, it was just north of $300 billion, which is an astronomical number when you think we're living in astronomical times. And so this $310 billion replenishment came in a way that recognized some lessons learned in the first round. One was that the big banks and the big small businesses that qualify for these programs were kind of dominating the program, and that the smaller small businesses were sometimes getting left out. And so there are a handful of regulations in place now to help facilitate smaller companies building relationships with smaller banks to carry out the Paycheck Protection Program. The big one is that 60 billion of the 310 billion is required to move through banks that have smaller than $10 billion in assets, or less than $10 billion in assets, I should say. So if you think about that in the context of local institutions, M&T is above that threshold, and then the other national players that are here are above that threshold. So like a Citizens, a Bank of America, and the list goes on, are all bigger than that. But that means the other local banks, the credit unions, the Evans, the Bank of Akron, Community Bank, you name it, there is a big pot of money that is required to move through banks that look like that. And so I've seen a lot of companies who aren't getting attention from their big out-of-state corporate bank for a lot of reasons, but have had some luck moving over to Evans or Bank of Akron, for example, and getting their Paycheck Protection Program loan approved and processed that way. The other thing that I think is worth noting on this front is it's a loan for 2.5 times your monthly average payroll, which is forgiven if you spend it within 8 weeks after getting the loan, with a minimum of 75% of the money going toward keeping your people working or bringing your people back to work. But one bit of nuance that is worth thinking through on this is that it has to get spent within 8 weeks to be forgiven. And maybe that changes down the road, maybe not. but it's important for people to think through, okay, if I need to spend it within 8 weeks of the loan coming through, then I want to work strategically with my bank to time the loan so that it doesn't come in until I'm ready to have people come back to work. So if you think about bringing people back to work is going to take some time. If nothing else, you have to be in touch with them and say, okay, we want your first day to be Monday the whatever. But you want to make sure that you're lining those things up. So all of that relies, really one big summary point is all of this relies on having a good relationship with your banker. And I've been encouraging everyone that I work with, including, a Catholic priest in his parish yesterday who was applying for the program. I've been encouraging everyone that I've been working with to really think through, where is it that someone who is going to be motivated to work with you, where you're not small potatoes and they are going to pull your email out of the thousands that they're getting right now about this and walk it down the hall to get it approved. And so relationships are super important, and maybe doing this at your community bank or your credit union is the way to do it. So that's it for me, and I'm sure we may have some questions later, but I'm happy to wrap up there, keep it quick, and let everyone else present.
Okay, thanks, Tom. Thanks for the update. I think Janine, who do we have next? Were you going to go next, or one of the Chris's?
Chris Moggins.
Okay, Chris, please introduce yourself, because we've not done a good job of that on this forum. On our meetup page we did, but talk about yourself first.
Sounds good. Hi, everyone. Thanks for having me. My name is Chris Moggins. I'm an attorney at the law firm Goldberg Segala. I practice labor and employment law and counsel and defend employers of all different sizes. For those of you that aren't familiar with Goldberg Segala, we were a startup company in Buffalo in 2001, started by 7 attorneys. We actually just celebrated our 19th anniversary last week. We had Spirit Week. We've since grown to more than 400 attorneys. We're in 20 different offices across 10 different states, but Buffalo, New York is still our headquarters. And our office, when we're not working remotely, as we have been for the last month, is headquartered downtown across from Shays. So one of the things I wanted to talk about today is a relatively unknown program to employers. It's called, New York calls it a shared work program. 26 states have similar programs, but we like to call it the shared work program in New York. And basically what it is it's an alternative to layoffs or furloughs or employment separations. And so basically it's administered by the New York State Department of Labor, and employers strike deals with the New York State Department of Labor to reduce the hours of their certain employees so that they can keep them on the payroll, keep them working in some capacity. But, given that they don't have a full 40-hour work week to work with, they don't actually have to lay them off. There's some very specific parameters surrounding it. The reduction in hours must be between 20% and 60% of the work. It doesn't necessarily have to apply to the whole company. It can apply to a department or a unit or lots of different delineations. The Department of Labor is pretty flexible on that, but it does have to include at least one person or at least 2 people. It won't work for just one person. It's only available to really your non-exempt employees. There's an FAQ online that I can share with anyone that's interested, and it specifically exempts corporate officers. But the way it works, the way it's structured, you really can't do it for any exempt employees. And when I say exempt, for those that aren't familiar, the exempt employees are the ones that you're paying time and a half for hours worked over 40 in a given week. It doesn't work for those people because it could actually destroy the exemption if they participate. So these are your non-exempt hourly employees that it could be applicable for. There's an application process. From my speaking with the Department of Labor, I've been walking clients through this. Typically, from when you submit the application, you could get rolling in a week or 2. They're actually kind of surprisingly very, very helpful and very responsive. If you haven't heard, the Department of Labor has onboarded several thousand people to help administer the unemployment benefits program and the pandemic relief, as well as this shared work program. So they've actually been very responsive and helpful with answering questions that employees have. And one of the things that people have questions about that have been coming up has been the relation of the shared work program with the CARES Act. So as you're probably familiar to a degree, there's the Coronavirus Aid, Relief, and Economic Security Act. And as part of that act that came into play on March 27th, there were different levels of pandemic insurance that were offered. And so there's basically, just to quickly summarize them, the first is pandemic unemployment assistance. And this provided eligibility for people that typically aren't eligible for regular unemployment benefits. So typically in New York, for your regular uninsurance benefits, an employee either needs to be, they need to be an employee, and then they'll only not get unemployment insurance benefits if they've committed some level of misconduct or they voluntarily separated without a good reason. But unemployment insurance benefits wasn't previously, available for someone that perhaps couldn't go to work because of COVID-19. So there is a laundry list of new coverages for people that previously weren't able to take advantage of unemployment benefits. The other component is, or two other components is, and people that are eligible can now get an additional $600 on top of their regular uninsurance benefits. So the way this would work with the shared work program is you'd have an employee that, let's say they typically work 40 hours a week, but you, through the shared work program, had reduced their hours to 20 hours per week. They'd be receiving the wages that you're paying them, and then for the 20 hours a week, they'd be receiving partial unemployment benefits through the normal New York State Department of Labor unemployment benefit system. And then they would also be receiving the $600 from the federal government under these CARES Act provisions. So this is interesting because at first we thought that you wouldn't be able to get the $600 unless you were fully on unemployment. That's not the case. The regulations and the guidance has provided that if you receive just $1 or more of unemployment benefits, you can also get the $600 from the federal government. That process has since been consolidated. It had a pretty funky system when it was first rolled out, where you had to apply to New York State for unemployment benefits, get rejected, and then apply again. That system didn't make a whole lot of sense, and the Department of Labor has since modified it so that you just put in one application and then you're set. And then of course the last piece of that federal package as it relates to unemployment benefits is, instead of the normal 26 weeks, it extends to 36 potential weeks in a year. One question that has been, or another question that's been coming up with regards to this is whether or not you can get these unemployment benefits if you're also on paid sick leave. The answer is no. The guidance and the regulations have made that clear. And I've been getting a lot of questions from employers about that because of the two major employment laws that were enacted under the Families First Coronavirus Response Act, which was a separate federal law that became effective on April 1st. It's had a lot of different questions come up, especially with relation to small businesses. So one of those laws is the Emergency Family and Medical Leave Act. This has been really confusing because under the regular Family and Medical Leave Act, in the private sector, only employers with 50 or more employees are covered. Under this new expanded act, every private sector employer with 499 or less employees are covered. So that's more expansive, and of course now includes for the first time folks that have under 50 employees. There is a little bit of a safe haven for small businesses though. If you have 50 or less employees, you can claim that providing such leave might jeopardize the viability of your business. What that means is extremely murky. Basically, what an employer would need to do is document specifically why granting a leave request under this statute would create an issue with their business. They don't submit it anywhere. The employer doesn't submit it to anyone. You just have to pray and hope that your reason's good enough. And if someone complains about it, that it holds water. The regulations specify a little bit more about what you need to actually declare in that analysis, but that is a safe haven for those small businesses. There's another safe haven for employees or for employers that are small. Typically, employers that offer this leave must restore the employee back to their original or an equivalent position. For employers with 25 or less employees, they may not need to do that. It depends on some very specific factors. It would be something that an employee needs to, our employer needs to look at very closely. So that's not a one-fit-all solution for all employers. The other major employment law under that Families First Act is the Emergency Paid Sick Leave Act. That provides up to 80 hours of paid sick leave for an employee. It's triggered in 6 different ways. One of those ways is identical to that expanded Family and Medical Leave Act. And so the small business exception also can be used as it relates to that particular triggering factor. There is no small business exception for the other factors though. So what to do for compliance? You're going to want to make sure you have a notice poster up, you update your employee handbook, you update your policies, and you update your leave forms as it relates to those laws. And also you want to make sure you're not getting it confused with the New York quarantine isolation leave law. That was a law passed on the same day as the FFCRA, very confusingly, and it was passed on March 18th. It became effective on that date. Some guidance has been released since then. It's a much more narrow law than the federal law. It's only triggered when an employee is subject to a mandatory precautionary isolation or quarantine order that's issued by the government. So this isn't an employee self-quarantining. It's not an employee getting a note from a healthcare provider saying that they might have COVID-19. They actually need to present a government-issued stay-at-home order. So it's much more narrow, and the interaction between that New York law and federal law is important because the New York law basically says it only applies to the degree it's excessive to a federal law. The implication of that differs depending on the size of your business because the leave is tiered in such a way that you only get you only have to provide certain amounts of leave depending on the size and revenue of your business. The last thing I wanted to mention is just some other recent legislative updates. The governor passed the budget on April 2nd, 2020. He always sticks things in there that have to do with employers. 2 of the biggest things are a change to the New York election law. You might recall last year that they changed the election law to basically offer more leave, offered 3 hours of leave for employees to go vote for elections. This change basically reverts back to the old law with a few different modifications, but that's something that just changed. The effective date of that law was immediate on April 2nd. And the second main thing in the budget was a new paid sick leave law that's required of all employers. It goes into effect 180 days after it was signed on April 2nd, so that's September 30th. However, employees can actually take advantage of that leave until January 1st, 2021. So you have a little bit of time for that, but for employers that don't provide leave that's as generous as that law, you'll need to modify your pay time off policies so that they are. I think that is my time, so I am going to mute and pass it along to the next speaker.
Great, thank you, Chris. And on to the next, Chris. We'll have some time for questions when Janine and Chris are done. Take it away, Chris.
Okay, thank you, everyone. Thank you. Thanks, Matt. My name is Chris Brown. I'm a partner at Roche, Lennon & Brown. We're a business law firm located in downtown Buffalo and with offices in Niagara Falls. So we focus on counseling small and closed-held businesses, startups, entrepreneurs, and young and developed companies through the entire business life cycle. We do kind of similar planning on businesses, estate and succession planning, and do estates and trust work as well, and some tax planning in that. It's an interesting time for our firm, and I think a lot of business firms, is because, we're seeing clients on 2 different sides. We have some business clients that are really thriving right now. We have one client, a manufacturer that just so happens to be one of the producers of part of the testing kit for the COVID-19 testing. They can't stop orders, and even their suppliers have said, and their end customers have said, don't stop producing until we tell you. So they're thriving. And then on the other side of the coin, we have small restaurants and mom and pop shops that are just trying to figure out how to just keep paying their rent, how to keep payroll to the extent they can. So it's in a lot of ways it's bittersweet because you're seeing both sides of it, but there's a lot of things to consider to this time. I wanted to just touch upon kind of a hodgepodge of business things that kind of I've seen throughout the last couple of weeks. One of which is just briefly touching on how to kind of approaches for terminating employees if you have to, how to furlough them, what is furloughing, some things to consider there. I'm going to also talk about the PPP and the EIDL loan. Tom, I apologize if I'm repeating some of the stuff you said. I know all of us, we probably heard about these loans day after day, so I apologize. But I think there's some points to it that everybody should have some concern about and also pay attention to know that the power of these and what it can do for business. And then finally, just briefly touch on anyone that has a brick and mortar shop and is a tenant and may not be sure what their lease says about circumstances regarding a pandemic. I can tell you, I'm sure most, if not all, leases really don't mention what happens in the event of a pandemic and what do you do in that case. So, I'll kind of flip-flop all over the place, but just in the first instance, in New York for terminating an employee or furloughing. So the big difference, as most of you probably know, is terminating is just that there's no place for employment when they come back. It's a permanent termination, whereas in a furlough, it's an unpaid leave of absence. So you're basically telling the employee, your job is here. You can't work now. You may be receiving some benefits. You may not be receiving benefits, but your job is basically secure when we tell you to come back. The big nuance with that to take away is it is incredibly important to, and especially in writing for your employees, that they understand what rights, what benefits they have during the furlough period, and what rights and benefits will return to them after the furlough period. Another aspect of that is making sure that if you have employees that are at will or under contract. What that means is New York is an at will employment state, so you can be fired for any reason or no reason at all, or you can quit for no reason or any reason at all. The difference is if you're a contracted employee, so if you have an employment contract with your employer and it states that you're entitled to work X amount of hours a week, that person may not be able to allow to get furloughed because it'd be a breach of their employment agreement. So you have to be very careful about who has an employment agreement with, who doesn't, and making those determinations of who can be laid off during this time. I have one client, they had to scale back some of their operations, but they had to rearrange the deck about who can be scaled back and who cannot because of that very reason. They have some employees that are basically hourly at will employees that they can flow, and others that are contracted and have a fear of doing that. So something to consider there. If you do have to terminate employees, a few things to always note for small businesses. Make sure if you do terminate an employee, with 5 days of their termination, provide them with written notice of the effective date that their benefits are canceled. A lot of employers do that, and you don't realize if you don't do that, it's a labor law violation. And I believe it could be up to a $5,000 penalty for merely just not providing that notice. We've seen it happen where employers don't provide that notice, and the disgruntled employee reports it to the Department of Labor, and they can get hit. And it's also important to make sure that your employees receive notice from you of their ability to apply for unemployment benefits if they are terminated. So that's just a little bit on the employment side of things, some high level things to think about during this time. Going into the CARES Act a little bit with the Paycheck Protection Program, and like I said, echoing what Tom emphasized and described, I think this is a good program. It could work in a lot of ways. Some things that we've been trying to figure out, and I think and kind of fleshed out on a day-to-day basis that I want to talk about is, and what people often have questions. Okay, it's a paycheck protection program, but what if I don't have employees? What if I don't even have a payroll? What if I'm self-employed? And we know now that those self-employed compensation, whether you're a sole proprietor, even a partner, or independent contractor, can be included in the payroll costs to determine the loan eligibility. And it wasn't until April 24th, a couple days ago, when the Treasury came out with the guidelines that says, well, if you're a partnership draws, those can be counted as payroll costs. Now, it's too bad that came out so late, because everybody that applied right on time for their payroll or their PPP loan that may have been a partnership and took partnership draws, those business owners weren't able to include their draws into their loan amount because there wasn't guidance on it. And if you got approved and you got your money already, well, you're out of luck, because your application's already through the door. But now, if you are a partnership, those partnership draws, the income that you draw as a business owner, can be included in that. Like I'm also mentioning, the loan terms for these PPP loans, it's a two-year loan at 1% interest. The principal and interest is deferred for 6 months, no prepayment penalty. You're not going to find a better rate and a better term like that under any kind of commercial lending anywhere. So even if your PPP loan doesn't get forgiven, and the only reason it wouldn't get forgiven is if you didn't use it for those qualifying costs, for your payroll, utilities, mortgage payments, and it just turns into an actual loan, that's a great loan still. And a lot of our clients are seeing that, well, we got money for this loan. Should we keep all our employees, or maybe we want to lay some employees off? They get to take advantage of unemployment and the additional $600 a week in unemployment. And we just treat this as a loan that at 1% interest, we're never going to be able to get that kind of lending anywhere. So if you kind of run the numbers, it might be a good way to just get some alternate financing as a loan that you wouldn't get elsewhere in the market these days. Another great benefit of the PPP loan, as we know, is if your loan's forgiven, that's great. But traditionally, loan forgiveness is includable in income for income tax. But under the PPP, loan forgiveness is excluded from gross income, and the expenses are still deductible. So it's a great tax advantage too if your loan is deductible. Another great thing about it is there's no collateral required, and loans are non-recourse, meaning there's no personal guarantee. The banks and SBA can't look anywhere else because the SBA guarantees it. And another beauty of it is the fees involved is that the SBA loans are usually pretty expensive when you do SBA small business loans, but SBA is reimbursing the lenders for the cost of providing those loans. So it's again, cheap financing. Moving to the other side, the economic injury disaster loans, the EIDL loans, as we call them. Like Tom said, we got another 60 billion, but they're no longer accepting applications at this time, and who knows when they're going to. I guess the SBA received over 5 million applications of this, and it's really crazy. So we may be out of luck at that at the moment, but I think it's important to just know what this is compared to the PPP, how it can be used. The biggest difference is your PPP loan is through a lender or bank, whereas this is directly through the SBA. You get a loan for up to $2 million. How much do you get? The SBA determines. So you send in your application materials, and they're going to tell you how much you qualify for. Again, but even the terms on these loans are pretty great as well. It's a 30-year term, fixed 3.75%, 2.75% for a not-for-profit. There's no personal guarantee, and the biggest I think perk of this, which we're all seeing and we're all probably heard of, is $10,000 cash advance. So once you apply for the loan, you're eligible for an automatic, well, not automatic, but an up to $10,000 cash advance, with just a grant. It's forgiven. That even if your loan is denied, and even if you don't accept the loan, it's yours. And that was kind of what everybody was running for at the starting line when this all came out, is to make sure that they can try to get that advance. And I know even getting that advance, it was supposed to take 3 days for them to send you your money, and I think it took more like 3 weeks. Um, Another good perk of the idle loan, there's no minimum credit score for businesses. You do need to have credit history, but there's no minimum credit score per se. Like I said, if you want to just apply for that $10,000 grant, you can. You just apply for the loan, and you don't have to accept it if it's offered to you. Another good benefit of it is that you don't have to be turned down by a bank first for lending. A lot of SBA loans require you to require what's called a credit elsewhere test, that you show that you've gone elsewhere for financing and been denied. You don't have to have that here. And you don't need collateral unless you have loans over $25,000. And if you get turned down for the loan, you have a 6-month period to request reconsideration. So these are some very kind of powerful tools that, the government's coming out, albeit it's been difficult to, and logistically a nightmare, frankly, to have these administered and for a lot of businesses. But I think it's important to know what these are and kind of where your business may fall in the mix of them. I guess some things to take away, especially for the PPP now, since that's still open, is immediately contact your banking partner. Better yet, it's important to contact the banking partner that you have the best relationship with, because like Tom said, you want to be on the top of their list. And if you have a pre-existing relationship with a bank or a banking officer, they're going to be prioritizing you over kind of walk-ins that come in for this. Make it a priority and apply. Don't delay, because these funds are available on a first come, first served basis. If your banking partner is a smaller community bank, there's been a certain amount of money actually earmarked for those banks to support the smaller banks. So even better yet, steps for the idle loan. Right now, there's not much we can do because they're not taking them. But if and when they do, it could also be helpful to talk to an SBA advisor to help you get through that process as well, just so you have all your ducks in a row. Moving on to another issue that businesses are facing now, and those with brick and mortar shops is, okay, I have a shop in downtown Buffalo. I can't be open for business because of the shutdown. Do I still have to pay for rent? And a lot of tenants are trying to look in their leases to see, how can I get out of this? Can I get out of this? And a few things that they should be thinking about, and some things I've come across of different clauses and provision leases that they should be aware of. One is what's called a force majeure clause. All that means is there an unforeseeable circumstance that prevents someone from fulfilling their contract? So a lot of contracts have these clauses in that says, each party isn't responsible if there's some event out of their control that prohibits them or stops them from being able to perform under the contract. What we're seeing that typically for rent payments, you're still going to have to pay rent payments, even if there's an event that is out of the tenant's reasonable control. And even in New York, kind of the overarching case law states that the event that is uncontrollable has to be somewhat specific in your lease or your contract, almost to the point where you'd have to say, in the event there's a pandemic, each party isn't responsible. Like I said, I can tell you, I'm sure most, if not all, commercial leases don't have that type of language, because we never envisioned this. And who would have, thought we'd be in a pandemic that would cause contracts to be unenforceable. So something to think about there. Another provision that I see a lot of tenants looking to is their casualty clause. The casualty clause says, if something happens to my store or my premises that I'm unable to operate it or use, I should be able to have my rent abated, or I should be able to get out of the lease. Those clauses are usually only for structural or physical integrity loss. So think about fire, flooding, smoke damage, or other kind of destruction. But simply not being able to operate a business does not per se mean it's considered a casualty, and it probably wouldn't be. So I think a lot of tenants lose on that clause as well, if they think, well, maybe I don't have to pay rent because of that, because this is a casualty. I can't be in my building. Another thing that tenants are thinking about is the default provisions in their lease that says that if they default on payment of rent, they could be evicted. A lot of tenants are saying, well, I don't think I had to pay rent because I can't be open for business. And therefore I have a valid and just reason for not paying rent because I'm not using my building. That's not enough. I mean, your landlord is still going to consider that a monetary default. And if and when the courts open back up, where evictions for residential and commercial tenants will be back in full force, they could institute an eviction proceeding. One way to kind of combat that, if you think there is a theory, there's something in your lease that you shouldn't be paying your rent, or that you have a right not to pay rent at this time, is you can file what's called a Yellowstone injunction. It's basically the tenant puts everything on hold and says to the court, I have a basically a disagreement with my landlord. He thinks I should be evicted. I think I shouldn't be. Let's put everything on hold until we figure out what this is. So it basically stops your landlord from taking any immediate action on an eviction, and kind of like a placeholder. All this stuff is really kind of theoretical at this point of how these things are being tested out, because we just haven't gone there yet. It's only been a month into this, where we don't know how the courts are going to rule on commercial leases and how tenants are going to respond to this. But I think the takeaway on this portion is look at your leases now if you're a commercial tenant, and look at your leases for the future if you're coming up on a renewal or looking for a new business in the future, of how do those provisions relate to your business and to a circumstance like we're in now. Because like you hear all over the news, could be another wave of this in the fall. It could be another year from now, we have another wave of this where we go back into the state of limbo. People may think, all right, we're out of it now for the summer, we're good, business back to normal, but we could be right back here. So if there's an ability to work with the landlord, work with business partners to kind of foresee these changes for the next year or two, or forever, just in case you ever had this type of circumstance, it's important to do it now. So a lot of information, a lot of different aspects of kind of what's going on in the world, the business world right now. But I just wanted to give everybody a flavor of kind of what we're seeing and some of the big issues that your clients or you as a business owner may be facing. So thank you for your time.
Thank you, Chris. Who knows when we're going to get back to normal, but it's happy to report that we're starting to think about it. Jeannie's going to talk about that. Before she does, I want to just let you know that next week we'll probably talk more about reopening and what that looks like. I've been asked to sit on with two groups that are basically saying, let's come up with our own plan for reopening and then give it to the government. Because if we wait for the government to decide, it may take forever, or it may take too long, or they may not think of some things because they don't know our industry. So I'm hoping that I'll have something to contribute about how different industries are going about reopening. But on a more tactical level, Janine's going to talk about you and your employees. Take it away, Janine.
Okay, thanks, Pat. Yeah, I'll quickly go through some important points. There's so much to this that I couldn't hit all of the regulations there that are hitting us. OSHA's got a ton of guidelines on this, and I have all those specific things. So obviously, if anyone needs more detail, you could just reach out. But some of the things that I would put on a checklist right away is to start looking at emergency plans and preparedness. A lot of businesses really don't do that as well as they need to. And I think this just reminded us that this type of thing is very important. So we have to look at those and review and revise as necessary. The social distancing is not going anywhere. So considering the shift staggering, all different work arrangements, and of course, sticking with the at-home work. I think, I know a lot of my clients are finding that to be actually quite practical, and they're getting used to it. So it's an important thing they'll need to consider moving forward. The other part of that I've been working with my clients on is consideration of reorganizing, restructuring. And, unfortunately, they are recognizing that some positions aren't necessarily as critical to their business as they once were. So we don't like to have people lose employment, but it is time to be looking at that very critically as well. As far as I can see, masks are going to be required. I think employers are required to provide those. Masks, along with other personal protective equipment, will be very important. So I would recommend right now, before we actually can reopen, that businesses take a careful look at the types of things you'll need to consider. You know, there's a huge supply and demand issue, so you'll want to talk to your suppliers to see how you can get your orders in as soon as possible. Safety and hygiene plans, gonna a real careful look at those, all the practices that you have in place, the regular and frequent disinfecting of workspaces. So cleaning procedures need to be reviewed, make sure all the modifications for disinfecting are in place. And I think a lot of employers are going to find that particularly challenging because a lot of them have commercial cleaners coming in, and how are you going to handle that? Something you really need to think through. Close common break rooms, conference rooms, basically tape them off. The idea here is that employers cannot offer space that would typically get several people mingling. So they're saying that you should really shut down those common break rooms and common gathering spots. The whole idea of the employer's responsibility to keep a workplace safe and healthy for workers. So that whole testing and taking of temperatures, which is extremely uncomfortable for some of the clients that I've talked to, will need a policy related, but there's a whole lot around that you know, is something that may be a new reality for a lot of employers. The COVID policies, there's very specific postings and policies out there. So they're templates that you could get a hold of and, you know, basically fill in as necessary, but I believe those should be in place already. Chris talked about the paid time off, leave plans and policies. I know I have to do a whole lot of edits to handbooks, a whole lot of edits to policies for my clients. And there's a lot of review of, again, organization structure that I'm doing lately. And then, of course, there's that eye on negligent suits. And maybe the attorneys could speak clearer on this, but it's standards of care. So there's a basic obligation of employers to make sure that their patrons and employees are entering and part of a clean, safe work environment. So there can be suits tied to an environment that some may believe have caused them to get sick, specifically with the COVID-19 virus. So I wanted to just do a quick overview because I really want to leave time for questions, especially having Chris and Chris here to answer any of your questions. So why don't we get right into that? And that's it for now. We can't, you're on mute, Pat.
It actually puts this thing up that says, hey, you dummy, you're talking and you're on mute. So, anybody got a question? Speak up or put it in the chat.
Hi, this is Maureen Ingham from St. Peter's School in Lewiston, and I appreciate being a part of all of this information, which, to be very honest, is very overwhelming. So Janine, get your pen ready because I know you'll be helping us. We've been working feverishly to update a lot of our handbooks, but will there be some specific written guidance for us to include with regard to temperature taking and spacing and tying off, you know, rooms where people have their lunch, where the teachers have their lunch? Will we be limited to the number of students in a classroom or students, excuse me, that we can feed lunch to in the cafeteria? Is that going to be coming down? Are we asked to use our best judgment? Help.
I can just speak to, I don't know, I don't think we know yet about the schools. I don't think the governor has really spoken very clearly on that. And again, our legal counsel here today can help us with that. But from what I understand with the common areas, they will have to have lunch at their desk. They're really going to be isolated. You got to picture that just anywhere they are, that's where they should be. They don't want anybody to be gathering. So conference rooms, lunch rooms, they have to do it different. That part I know. What about Chris and Chris? Do you know anything about I mean, if they're going to be limiting numbers of people and 6 feet distance, you'd have to be setting up your classrooms that way. And I will say this, that I've looked into this quite a bit because there's a lot of interesting information out there. And there's new designs of office space now that literally have, let's say, rugs that show the distance that people can come when they're approaching a person. They have arrows so that you can only walk one way in a hallway and come back another way. I mean, there's a whole lot of things out there. They're putting up this glass, I guess it's a plexiglass, at desk space so that there's that barrier. Anywhere that the public comes in, they're trying to encourage them not to anymore and just call and do video conferencing and councils that way. But anyway, anybody else have anything on that?
I do after Chris and Chris.
This is Chris Moggins. Governor Cuomo, as you likely know, has a press briefing every day. I watch them, and basically what he's saying in the last couple of days in particular is, he's starting to reopen businesses starting on May 15th, but it's going to be on businesses to come up with their own individual plans as to how they're going to do it. So right now is the time for every business to be thinking about how exactly that's going to work for them, regarding social distancing and making sure that employees can stay safe if it's possible for your company and your industry. So I wouldn't, I think Pat mentioned it, I wouldn't wait for the government to detail a plan. But with some of the things that you brought up, I mean, part of the issue is there's piecemeal information and guidance from several different agencies. So the Equal Employment Opportunity Commission released an updated pandemic, guidance that basically throws out the Americans with Disabilities Act and says that you can, take the temperature of employees, and it's got a Q&A in that guidance. But that guidance can't be looked at in a vacuum. I had a client the other day that was telling me that they were going to do that, and I said, that's great. When do you plan to do it? And they said before they clock in. I said, don't do that. That's a wage and hour violation. You're going to violate the Fair Labor Standards Act and New York labor law. Think about donning and doffing. So, all of these things, unfortunately, we get guidance from all these agencies, but they look at it through a vacuum of their own agency, and they don't think about necessarily all of the other potential laws that are out there. So anything that's being changed about the business really needs to be considered from the whole, cast of federal and state laws that could potentially be triggered.
Thanks, Chris. I'll give you an example. I'm a part of a group that is looking at how to open the border between the United States and Canada. And we have members from coast to coast, from the US side and the Canadian side. And rather than wait for the two governments in Ottawa and Washington to come up with their plan, we're coming up with a plan, and we're going to present it to Washington and Ottawa and say, what do you guys think of this? Because if you think about the situation the government is in, especially the state governments, it's got to be overwhelming to try to understand how every industry works and to try to figure out what works and what keeps people safe in every single industry is just mind-boggling. So my suggestion is, if you have an organization that you belong to, there's strength in numbers. So if you belong to a trade association or a chamber of commerce or a business association or some group, and you can get together quickly and figure out what the best plan for your industry is, and then get it down on paper and then present it to the state, probably through Empire State Development, and say, here's what we think is a logical way to reopen the business, and not demanding that it be that way, just trying to help. I think if you present it in such a way that you're trying to help the government because they got to be overwhelmed, it's a proactive way to get ahead of this. And these are the groups that I'm involved in right now. And I hope to talk more about that next week, because we're starting to have meetings now.
I think businesses too should just start taking into consideration existing guidelines that we all know of, whether it's from the World Health Organization or the CDC of social distancing, and use that as a baseline for returning to work. I think to Maureen's point on the school side of things, I'm not sure how the governor and state's going to work with that, but I'd imagine I would hope at least there's going to be some guidelines on how that gets integrated and on how that's phased in. And to your point, Maureen, I think that hopefully should illustrate, is there a capacity limit that we have going into it? Is there a distance between students of where their desks are or the interactions? Hopefully we do see that from the school side, but like Pat said, at least on the private sector side, from the business side of things, using the existing guidelines as your baseline for a policy, that's a great starting point, and a starting point where you as a business can say confidently that we are following at least the minimum guidelines for this, to avoid any kind of liability that you're careless in not upholding the standard of care for social distancing for the time being.
Thanks, Chris.
I think the good news on schools is it's going to be a while. This is not going to be May 15th, I don't think. So if you can get together with other schools and other school districts and other parochial schools like yours and present a group think, and this is what we think we ought to be doing, it would probably be appreciated by the state, I would think. They got to need help.
And I think the first phase is manufacturing and construction, isn't it?
Yes, May
Yeah.
15th.
Okay.
Some manufacturing.
Right.
Depends on the ability of the employers to provide a safe environment.
Exactly.
So again,
Yeah.
Who determines that?
Right.
It's going to be difficult.
I had a question about the FAQs, Chris, that you mentioned earlier for the shared work program. Is there any way you could share a link on this chat to the FAQs? You mentioned you might have that.
Yes, it's on the Department of Labor website. I can shoot that over.
Okay, thank you. Are there any other questions or comments?
Just more questions.
Go ahead, Maureen, you have them?
No, I just mean that the questions are unending.
Yes, they are. They definitely are.
The answers is what would be great.
Yeah, we're all.
I do appreciate hearing all of this. And actually, we do have a regional principals meeting tomorrow, a Zoom meeting. So I'm happy to share a lot of this information. And most particularly, we need to be our own boss here and come up with a plan, at least for someone to look at and say, this part is good, this part needs some changing.
Mhm.
So at least that's good direction for us.
And Maureen, any help you need with that, let me know.
I
too,
got
so
your
we
number,
can-
Janine. Thank you.
Okay. All right.
So any suggestions for topics next week or following weeks, please let Janine and I know.
And I do want to jump on that. Next week, we do have a licensed social worker coming on to talk about the Zoom fatigue, work-life balance, and the mental health related to everybody kind of glued to the computers these days. What the mental health counselors are finding is that between parents, kids, and then those of us working all day on them are really starting to have some psychological effects. So we do hear from time to time that mental health during all of this has been such a big issue that we will be visiting that. So that'll be Zoom fatigue and work-life balance. And then whatever, Pat, you're going to cover. And Pat and I will be meeting Friday to talk about any other topics, because obviously we're staying on top of all the hot issues, but we really do appreciate if you could help us with things that you're hearing so we could get the subject matter professionals on with us like we have every week. We really appreciate you taking the time, Chris, and Tom's here every week to update us. And being that they are recorded, I generally get people, and probably Pat does, emailing for the recording because they're on so many they couldn't get onto ours. So I think we do have a good audience out there. And so you know that others will also hear this information as well. But thank you all. There's no other questions? Okay.
Thank you.
Thank you.
Everyone.
Have a
Thanks,
great
everybody.
day.
Thank you,
Bye-bye.
everyone.
Bye-bye. Hmm.